back on the meeting. Here we go. Okay, it's going to start in about 1 minute. Okay, thank you so much.
Silence your phones.
All right. Yeah. Good morning, everyone. My name is Robert Glassman with the firm here at Panish & Boyle. I want to welcome you all to this morning's press conference. Thank you for taking the time to be here. We appreciate it. What I'm going to do is introduce to you our partners in this case. We have Bob Mongaluzzi and Jeff Goodman here. They are maritime lawyers who specialize in cases like this. They've handled a number of high-profile limitation liability cases like this one, including most recently the duck boat cases out of Branson, Missouri. So without further ado, I'm going to hand it over to Bob here, who's going to talk to you a little bit about the case, a little bit about today's filing, and answer any questions you have. Thank you.
Thanks. Today we have filed claims on behalf of 4 of the victims who were killed in this terrible tragedy. They are Ali Kurtz, Yulia Krashenaya, Kastub Nirmal, and Sanjiri Diapajuri. Their families have asked us to do 2 things: to find out what happened and to make sure it never happens again. This devastating fire took place in the early morning hours of September 2nd, killing 34. In what could only be described as cruel and heartless. Truth Aquatics, Inc. went to court seeking a judgment saying that these lives were worthless on September 5th, before many of the bodies had been found, identified, and before these families could mourn. This was a heartless, callous act which inflicted further pain on these families. This actor had 6 months to file that claim, but chose to do it immediately, lawyering up without any concern whatsoever for the people that they've killed. They have filed a limitation of liability action. That is an area of the law that most attorneys are not familiar with. It was passed in 1851 to protect the shipping industry. It requires that if the defendants are negligent, in order to escape liability, they have to prove that the vessel wasn't unseaworthy and that they did not have foreknowledge of what could occur. We will demolish their limitation of liability action and defenses and hold them accountable on behalf of these victims. There is now a July 1st, 2020 deadline. In most cases, in virtually every case in the system, personal injury or wrongful death claimant has 2 years to file that claim. Not so with limitation of liability action. The defendant has sought to shorten the period of time in which these families can seek justice. I want to talk a little bit about the areas that we intend to focus on in destroying their limitation of liability action. And I first want to start. Okay, we getting feedback? There, we're good. I want to start first with Nightwatch. Federal law 46 CFR 185. Federal law requires that the owner or operator of a vessel carrying passengers at night has to have a suitable number of watchmen patrol. This has become more important over the last decade as electronic devices on ships have proliferated, much like on planes. It is one thing to have a roving watch at night when, for example, you could say nobody's going to be in the galley cooking anything because it's the middle of the night. Nobody is going to be in the engine room constantly because the engine isn't underway. But when it comes to ion batteries and when it comes to charging stations, that risk of fire, particularly on older wooden and fiberglass ships, is something that is with us 24 hours a day. The National Transportation Safety Board report, preliminary report, has concluded that there was no night watch. And that is certainly buttressed by reports that all of the crew was asleep at the time this fire broke out. That is a violation of federal law. There are ways for them to manage charging at night. Jeff's going to talk a little bit about that. But the issues that are going to be confronted in this case is what policies did this vessel owner and captain have, and were they followed? There have already been reports from other captains involved with this same company saying there was no systematic night watch. It wasn't part of the company policy. And it was done at an ad hoc basis, usually only when there was bad weather. We are asking that anybody who has information that would be helpful to these families to learn why their loved ones died and to prevent it from happening again, contact us. If you were on that vessel and you could talk to us about night watch, call us or email us. If you were on that vessel or a former crew person who's no longer with the company and have information about that or about the charging stations, call us or email us to help these families. I want to last talk about another federal law, and that is 18 U.S.C. 1115. That's a criminal statute. It is known as seaman's manslaughter. Criminal issues for vessels at sea with passengers relying upon their captain, crew, and owner are very different than virtually any other type of liability under criminal and federal law. Criminal liability will attach. Manslaughter will be proven by mere negligence if any of these crew members, captain or owner, was negligent, did not discharge their duties properly, they are subject to potential criminal violation. And I can tell you that that criminal violation for the death of one person is 10 years, not to exceed 10 years. We are familiar with the interplay between criminal and civil liability. We were the lawyers in the Philadelphia duck boat case that killed 2, the Branson, Missouri duck boat case, which killed 17. In both of those, the U.S. Attorney's Office brought criminal charges against those captains. In the Philadelphia case, that captain has had pled guilty, served a year in prison. The Branson, Missouri duck boat captain has been charged with 17 counts of manslaughter. That case still is pending. With that, I will turn it over to my partner, Jeff Goodman, who's going to talk to you about 2 of the other core issues in the case, which includes the ion batteries and charging and egress and escapability.
When you are on a vessel, fire prevention and fire detection are essential for the very reason that if a fire breaks out, help will not get there in time. It is up to the crew, led by the captain, to make sure appropriate fire prevention and fire detection policies are in place. Bob spoke about the lack of a night watch, which is one of the egregious failures by the captain and by Truth Aquatics in this case. However, there are several others that are also essential. First is the lithium ion batteries. It has been pretty universally reported that the charging stations for these batteries are primarily in the galley. And to give a little more background, we're not just talking about cell phones here. This is sophisticated diving equipment that has tremendous power outputs and requires tremendous charging inputs. You have underwater scooters, underwater video equipment, underwater camera equipment, underwater lighting, all of which relies on lithium ion batteries. Now, the benefit of these batteries is that they're rechargeable. That's why we have them in our cell phones. The problem with these batteries is that they can overheat if they are not monitored properly. In this case, the method that was being used by Truth Aquatics was in no way safety assessed to determine how we should allow the charging for this considerable amount of equipment that our customers and our passengers will need to charge. The problem is if you have one lithium ion battery that starts overheating and it is in contact with others, it will cause them to overheat. If you have a grouping of lithium ion batteries that are in the area where a fire begins, the fire will propagate, it will spread, and it also burns especially hot. There are numerous ways that a responsible company can make sure that this doesn't occur. There are lithium ion charging devices where you keep it in a fire suppressed container. There's fire suppressing bags that are used. There's a variety of fireproofing measures that make sure if there is some incident, this doesn't happen. They're also cheap to do. It's an easy fix and a problem that can be avoided for just a couple $100. Truth Aquatics, unlike so many others in this industry, chose not to do that. The second main area of concern when it came to once the fire started is how do you get out? These passengers and crew member were below deck. When you are below deck on a vessel, the federal regulations require 2 means of egress, 2 ways that you can get out, for the very reason that a fire or some type of other hazard. Go. Federal law requires 2 means of egress, 2 ways to get out, for the very reason that in the case of a fire, one of those methods may be blocked. One of those methods may be leading you into the fire. In this case, Truth Aquatics chose through their design of the vessel to have 2 means of egress that both led to the same place. And in this case, that same place was the galley where the fire began. The failure to have redundancy, different means to get out, gave the victims trapped below deck no way to get out of their bunks, no way to get free of this fire, and resulted in 34 horrific, agonizing deaths of the victims. we are happy to answer any questions that you guys have.
Would you mind doing the names and pronunciation, obviously, both speakers, please?
For both speakers, I'm Jeff Goodman. My pronunciation's easy.
I'm Bob Mongalusi.
Just in front of the mic, please.
I'm Bob Mongalusi.
So is this is a response to their claim of exemption?
The way that it works in a limitation of liability action, because Truth Aquatics, callously as Bob described, filed a complaint 3 days after the tragedy, the way that the legal pleading has to work is we file an answer to that complaint and a claim in that action. Our claim is what you would normally see as a complaint in a more traditional wrongful death proceeding.
And it's federal, this is federal.
It is in federal court. We file our answer and claim in the courthouse where they filed their complaint.
So the first step is you have to sort of overcome their limitation of liability. And how do you do that? And then if you do that, then you proceed with your lawsuit. Is that correct?
Let me go through the steps because it's different. It is a multi-step procedure. We would first have to prove negligence. Once we prove negligence, then the burden shifts to them to prove their vessel wasn't unseaworthy and they didn't have what the law calls privity, which means knowledge beforehand. Obviously, that could be that's a burden that they're going to have to satisfy when it comes their turn.
And what do you have for showing that they had knowledge?
Well, we have, I'll start with the Nightwatch. There have been reports that, and it's not only prior knowledge, and I want to elaborate on this. The Truth Aquatics could also be found responsible for their failure to adequately train and to have policies and procedures, because those are all shore-based decisions. Going back to the Limitation Liability Act of 1851, that was passed when ships left America, sailed halfway across the globe. There were no communications whatsoever, and they did not want to hold ship owners to be responsible for decisions that were made half a globe or 18 months or 24 months away. What they did say that you'll be held accountable for would be a vessel that was unseaworthy, inadequate training, or inadequate policies and procedures. Here, from what has already been reported, there was no systematic requirement for a night watch person, and that has been something that has been reported by at least 2 or 3 of their captains on either worked for them before or still work for them now. That is an abject, utter failure to comply with the law. That would be sufficient to be able to destroy them on limitational liability. Failure to train their crew members would be another way in which to beat this. The lack of access, being able to escape. I think many of us have seen the photographs that show that the second means of escape was a hatch above a bunk bed, meaning you would have to go up a ladder to get to the second level of a bunk bed and then crawl underneath and then try to pop out of the top. It is a ridiculous potential avenue of escape. So there are multiple issues. And then there's the issue of the batteries. It has been reported that they had a prior fire year earlier and did not learn from it. They were lucky enough to have discovered it and thrown the battery overboard. But it did not prompt what it should have prompted, which was a rigorous examination of what the issues were and a very careful and controlled method in which to control the hazard of battery fire, particularly when everybody was sleeping below the charging station. Because if that went on fire, they were trapped and they were going to get burned and asphyxiated to death. So there are multiple ways in which we will establish that they had knowledge beforehand, that their training was inappropriate, and that their policies and procedures were deficient.
If I can add one thing to that, because this was a seagoing vessel, the captain's knowledge also applies in this case. And if the captain had any knowledge of any of the negligence, that also gets past any limitation claim.
The captain is like an extension of the owner in that instance?
Exactly, on a seagoing vessel, which this was.
You had mentioned there was a solution, a $200, I think you said, solution to the battery charging issue for as a lithium ion battery charging that they didn't implement or purchase, I guess. What is that?
There's many different fireproof containers that allow for charging. One of the solutions is called a LiPo bag, L-I-P-O. It's a bag that you put your cell phone in, you charge it in. There are larger options for the larger devices that would have been required in this case, but they are fireproof, explosion-proof containers that what many responsible captains do is they require anything being charged goes into one of these containers. You can plug in through that method, and then if something happens, it's contained.
Is there ever been any suggestion that Allie Kurtz was supposed to be the person who was on watch?
No.
Can you provide some context, historical context of trying to challenge the limitation of liability? Is that something that happens regularly or successfully challenged?
I wouldn't say that it's regular. However, it's something that we've encountered on several occasions. For example, in the Philadelphia duck boat accident case, which was when a barge struck a duck boat on the Delaware River in Philadelphia, sinking the duck boat, killing 2 tourists. A limitation on liability action was filed in that case by the owner of the barge and owner of the duck boat. In New York, there was a boat that capsized 4th of July several years ago. Cabin cruiser sank, 3 children drowned. That was another limitation on liability proceeding. We handled that proceeding. We defeated the limitation on liability proceeding. And then the Branson, Missouri duck boat tragedy from last summer that many of you may remember, where 17 people drowned when a duck boat sank during a storm. In that case, about 2 months ago, the limitation on liability action there was also defeated. So it is a legal procedural tool that responsible parties often use to try to limit their financial exposure.
Are all 4 of your plaintiffs, were they passengers or was one also a crew?
Allie Kurtz was a crew member. The other 3 were passengers. They were all sleeping below deck.
Are those other 3 all the same family members, or?
No. Yulia Krashenaya, who is from Berkeley, California. And then we also represent the families of Kustab Nermal and Sanjiri Deopajari. Kustab and Sanjiri were husband and wife. They were from the greater New York area. Yes, they're in the photograph together there.
Okay, and that's Yuli?
Yes, that's Yulia. And then this is Allie.
Okay.
Can you point out on the boat where the charging ports were?
So the charging ports were in the galley, which is basically this second level here.
But where specifically? Closer to the first exit or the second? Or were they
We believe they're relatively centralized within the galley. There are outlets at different places that also could be used. Prior voyages of this vessel and the other vessel is they basically just got a bunch of extension cords and a bunch of surge protectors to increase the power outlets that would be there. So they were scattered throughout that area.
What happened in that previous incident on the Vision with the battery? Like, what time of day did that happen? How did they discover it? I didn't know the details about the battery being tossed overboard.
Yeah, so there were news reports concerning that incident, that at some point prior, it was in that case a cell phone that had overheated and caught fire. They noticed it right away because it happened when people were awake. I'm not aware of the precise time of day. And they basically just threw it overboard as a way of making sure the fire didn't spread. That would be what is in the risk management industry known as a near miss. Something happened, it didn't result in injury or fatality, but in the industry that is something that should be assessed to look at why did this happen, what are the likelihood of happening it again, and how are we going to minimize the risks associated with it. In this case, Truth Aquatics didn't report it to the Coast Guard, didn't bring in safety professionals to reassess what they were doing, and had they done so, they would have noticed this problem.
It wasn't reported to the Coast Guard.
Correct. That based upon the reports we've seen, we have found no record of it being reported to the Coast Guard. By law, it is required to be reported if there is over $75,000 worth of damage. Obviously, a cell phone didn't reach that level.
And did that occur on the Conception, or was that on a sister vessel?
The Vision, sister vessel.
And what if they don't ever, there's been reports that believe that they may never find the cause of this. So you're sort of suggesting that the lithium ion battery station, the charging stations, the batteries caused the fire. What if they never come up with a cause?
Whether they come up with a cause doesn't mean that it cannot be determined by a jury. So let's think about the confluence of circumstantial evidence. Everybody is asleep below. There is no suggestion that anybody who was in the lower sleeping berth was doing anything. According to the reports of the crew members, they were all asleep at the time. The fire, by every account, breaks out in the galley. The chef is not awake. It's 3:30 a.m. There is no cooking going on. The only potential fire risk in the galley at that point would be these power strips, charging stations. We have a prior incident where they had a fire with a cell phone that was being charged. When you put together the constellation of evidence, it appears that it is highly likely that the suspect would have been one of the batteries that was being charged. And I think at this point, and now maybe with more evidence, and remember, at this point we're just filing. We don't have access to the evidence. The National Transportation Safety Board has all of the evidence. We will not have access to the evidence till the National Transportation Safety Board has finished their investigation and releases the evidence. But we could also tell you, based upon being lawyers, and I've been doing this about 40 years, I don't believe in coincidence. It just so happens it starts there, where all the battery charges are, where nobody else is up at night. What else occurred? Wasn't a lightning bolt.
Do you have you spoken to the other family members, and do you have a potential of representing more families?
I'll let Jeff handle that.
We've had conversations with multiple families. Can't really comment on who exactly has spoken to us outside of the lawsuits that we have filed today.
Which of the victims had been on the boats before?
Which of these victims had been on the boats before? Allie had been on the boats before as the crew member. The other three who we represent were avid divers. None of them had been, I believe, specifically on the Conception before.
You talked about how the captain may have had knowledge, or you allege he had knowledge of these policies where there was no roving patrol. How is that going to work? Is he going to be named in a separate suit and not with this answer to the liability claim? Will that ever be sought, naming the captain in litigation?
Yeah, right now we can only answer and claim against the Truth Aquatics and Glenn Fritzler, who are the two plaintiffs, believe it or not, in the case. The victims are known as claimants. So right now, by court order, any potential lawsuits have been frozen, and this has to be litigated first.
Do you know how many cases have been filed previously? I know one of the crew members has filed, Ryan something, and the Dignams.
Yeah, we believe one death case has filed a claim, and then one of the crew members, I think, who broke his leg in jumping from one level to another. And then there'd be these four.
If there were other claims, they have to file it under this docket, so they're not there. So we're pretty confident there aren't other ones out there.
What's the time frame of cases like this? How long does it take for this to play out?
Well, that depends. The Branson, Missouri case from the civil litigation, we are most of that case is settled, and that occurred within 18 months. We've had other cases which have taken years. In the duckboat case in Philadelphia, I would say that went to trial maybe 3 years.
22 months after the
Okay.
the accident.
22 months after the accident. Sometimes it's a little bit longer. Right now, nothing can happen until that July 1st deadline, because the court is going to wait until everybody has either filed or not filed. They will then hold a pretrial conference, and then we will sit down with the court and discuss discovery. We cannot take discovery until that time.
Were they insured?
Don't know the answer to that.
What was the outcome in the Philly case? Was there a jury verdict in your favor?
No. In the Philadelphia duckboat case, the case resolved. There were 2 deaths and a number of people who went into the water and survived. And the case settled for $17 million. The two death cases received $7.5 million each.
And the limitation proceeding is a bench trial, not a jury trial.
In recent years, there have been other incidents on the water, not as significant as this, but Invicta, Prowler. Does this speak to a greater issue with the industry or more oversight that's needed?
How do I put this? The safety starts with the individual vessel owner and captain. There are hundreds of thousands, if not millions, of vessels throughout the United States. While the Coast Guard certainly plays a role in passing regulations, the prime obligation to take care of safety is with the individual captains and owners. So in terms of is there a trend, there's certainly in this realm, let me put it this way. The maritime industry has not done a good job of keeping up with technology. The airline industry has done a much better job in terms of how to handle the hazard of ion charging batteries. And the maritime industry has utterly failed to take appropriate precautions.
Any more questions?
Does the Limitation Act have any protections for passengers rather than just cargo, or how are they categorized?
The Limitation Act provides that there is, if in fact the vessel owner prevails in the limitation claim, it says that the amount of monetary damages available for passengers or lost cargo is the total value of the vessel. So in this case, that is zero because this vessel is worth nothing. So if they were to prevail in the limitation action, which they will not, but if they were, then it would mean that none of the victims are entitled to a single dollar of recovery because their liability is capped at the value of the vessel.
And to a follow-up for that, let's say that Lola is defeated and everyone, all 34 victims or however many, are free to go and file actions elsewhere in other venues. Do we know at this time where we plan to file?
We haven't made that decision at this time.
But you'd be able to file that, this is state court?
Yes.
As opposed to the federal court? So it's just the liability, it's just the Lola action that has to be handled?
Yes. Yes. Under federal law, when a limitation liability action is filed, all claims, if they've already been filed, and that in the Duckboat case, there were already claims filed. They got all brought in, some in state court, some in federal court. They get all brought in to one place. It's called a concursus. And then until that limitation liability action is decided, one way or the other, everything else is state.
Is this still considered a lawsuit, just for procedural purposes?
Yes. They filed the lawsuit,
So you're filing a
and we filed our answer and counterclaim.
Any additional
Any-
questions?
Thank you very much.
Can I just get a picture of the two? I want to get all three photos, but he keeps standing in the way.
I agree. I'm gonna scoot
Sorry,
this one
I
out.
don't mean, or you can be in the middle, whatever.
Hey, Robert.
Do you want all three
over here?
victims
Sorry.
on the same side over here?
No, it's fine in the middle there. Thank you.
Thank you, everyone.
Oh my gosh. Hey, how are you?